Yep, you can start, Bob.
All right. Thanks, Johan. This is what we presented to the board last month, but I wanted to let everyone know that at the beginning of 2024, we were served with a class action lawsuit in California. It involved timekeeping, what is called wage and hour litigation. Just to kind of give you some context, wage and hour in California is really what plaintiffs' attorneys really go after because it's a very easy case to win in California. You can see that the California Trial Lawyers Association is a very powerful lobbying group because the laws in California are designed to help attorneys. And I don't mean to be melodramatic, but it is what it is. So employers have to be very vigilant to prevent and be very proactive. So I've had the unfortunate experience of major class action lawsuits at Abercrombie and Fitch and Red Bull and Target, a retailer. So unfortunately, I've testified at 53 trials and depositions over my career just on wage and hour. The demand we got at Santa Cruz Bicycles was $6.5 million. So we had to take this very seriously. I do want to share with everyone that we did take proactive steps before the lawsuit. I don't want you to think the team and I were sleeping at the wheel. However, in California, a class action goes back 4 years from the date the suit was filed. So it was filed in January of 2024. So we have to be prepared to go back and defend all of our timekeeping records from January of 2020 to 24. I started in 22 and had identified a few issues. I'm not going to cover all of these, but just the really common ones for any of you that have businesses, pawn businesses in California. If your employees get texts from their managers of any kind, or there's a GChat function on a personal cell phone, you're liable. The company is liable if they don't pay a phone stipend to every employee, every hourly employee, and quite frankly, any employee. The law doesn't state an amount. It's de minimis. So again, prior to the lawsuit, we paid all of our employees $5 a month for anybody that used a cell phone of any kind. So that's one thing I wanted to share. The second thing I wanted to share was at the bottom, revised attestation statements. Well, what does that mean? Every time an hourly employee clocks out at the end of the week, there's a statement that all my hours are correct. I haven't worked off the clock. All these different things. We didn't have that before, but we have that now. And again, this is prior to the lawsuit. And then we removed clocking in and out for breaks. We had an employment attorney that advised us years ago to have employees clock out for their 10 or 15-minute breaks. That really hurts you because if they don't clock out for that break, it automatically shows as a violation and it's recorded for 4 years. The law does not require that you punch out for a break. It only requires that you punch out for an unpaid meal. An unpaid meal break or a lunch. So here's where we had exposure. The first thing I would encourage anybody is to make sure that if you have employees in California, that they sign an arbitration agreement. And basically what this does, it's a contract between the employee and the business that you will not enjoin a class action lawsuit, that you will deal with an arbiter or a mediator. We implemented that after the lawsuit, which actually helped us defend it. We require it that any new hire that starts with the company does it. And the law states that the employer can compel somebody, meaning they can terminate employment if the employee refuses. The other big issue that I would encourage you is we switched our HRS system. So we went from one system to Workday in June of 21. And there was about a year and a half where we didn't pay meal period penalties. Meal period penalties being if someone doesn't take their lunch by the 5th hour in California, you owe them 1 hour of pay. If someone doesn't take their break, you owe them 1 hour of pay. If they get interrupted during a lunch or break, you owe them an hour of pay. That hour of pay isn't really significant. It's just in California, the penalty is you times that hour by 8 and then by 30 days. So one violation could cost you $5,000 if it's not paid on time. And that's where the attorneys really make their money. I'm not going to go through all of these, but the big thing I would also encourage you is if you are Google Suite or even Microsoft Teams, and there's a GChat function connected to people's personal phones, that really hurt us. We had supervisors, hey, where's that tool? Or where did you leave that paperwork for the bike build? And that really was tough on us. So what did we do? When you get one of these, it's really hard to defend, but I'm really proud of the team and the coordinated effort we had with both Magnus and Maddie D and our PON general counsel, as well as our outside counsel. We implemented immediately an arbitration process. 95% of our employees signed. We reached out to a couple hundred employees, 320 to be exact. That's very time consuming because some of them were former employees. Remember, in a class action, it's not only your current employees, but it's anybody that's worked there in a 4-year period. So initially, if you look to the far right, our class size was well over 300 employees. And by getting releases, the release being, hey, we informed employees we're getting sued. We don't think we did anything wrong per se, but we're going to offer you $500 if you voluntarily sign this release, removing yourself from the class. I've never worked for a company. I've done this before, but I've never worked for a company where everybody, including former employees we fired for misconduct, that signed it. We had over 91% signing rate with former employees. But I think that speaks to the culture, the brand, and that people, even people we fired, said, hey, the company was really good to me. I don't want to be a part of this class action. So what did it cost us? Well, it could have cost us $6.5 million. There was a local business that just settled for $5.9 million. I'm proud to say we settled all in for about $800,000. You can see, obviously our legal defense is not cheap. But all in all, it was $1.1 million. And this is the last slide. I know it's kind of a lot of information, but there's a couple things I wanted to highlight. We did change, California requires you take at least a 30-minute break, a lunch. But what happens is if an employee clocks in early, they clock in at 29 minutes, it's a meal period penalty. Sometimes employees do that to manipulate. Sometimes employees just, they lose track of time. So we changed the minimum lunch period to 45 minutes to avoid that. That's also helped us. There's a calculation on wage and hour error rate, meaning how often you're in violation. Prior to 2022, we were at 23%. Post 2023, we were at 0.1%. And that really helped us in the lawsuit because when the mediator reviewed it, it showed that we had already cleaned it up before the lawsuit, which matters in the settlement. The other thing is we worked with IT to remove GChat and email access for our hourly workers. Really significant and protects us in a meaningful way. And then we've implemented that all hourly employees and all their managers, including all the members of the management team, attend trainings because we built ourselves, Lauren Dockendorf and the training team built a 2-hour workshop for managers where we educate them on, we made up a Santa Cruz hypothetical person. We go through all these different scenarios all the way. I'm not going to go through all of these, but where we educate them on what their role is as managers and employees. We talk about some of the specifics, and then we go into like travel time was a big thing where we had violations. I'll get to it real quick. So we have some people that go to dealer events. And so we kind of explain to them what is compensable time, what isn't. And then last but not least, we did a workbook like we always do. So people walk away, and then there's an interactive component to this 2-hour training. So all in all, a lot of effort, if you will, a lot of learnings. And I always like to learn from our mistakes so we don't repeat them. So that's why we've reached out to every leader. But I really think our biggest exposure is in California at the Vacaville and Rancho Cucamonga Pond Bike warehouses, where they're predominantly hourly associates. And then I'll also say the person that started this lawsuit, his name was Tyler Emery. He'd been here 5 years and 8 months, never been written up, stellar employee. On his exit interview, he said it was the greatest place he ever worked. Wrote this really nice letter. But what happened is he had a previous workers' comp claim. And when workers' comp attorneys actually give cases to wage and hour attorneys, there's this kind of little behind the scenes network. So when someone hurts their arm or their shoulder, they go see a workers' comp doctor in California. Those attorneys that do workers' comp refer people's names to employment attorneys. The law firm that sued us was based in Beverly Hills, California, which is 6 hours south. They advertise on Instagram. When you drive through Los Angeles, you'll see posters on the freeway or billboards that say, "Have you ever not taken a break?
Yeah.
Call 1-800. We'll get you money." The other kind of dirty thing, nothing against lawyers, Magnus, but nothing against lawyers, Christine. But in California, when you get like that $1 million settlement, 40% goes to the attorneys, 30% goes to the state of California, and only 30% goes to the employees. So it's kind of it's gotten so bad that's why a lot of businesses are moving out of California. Folkert reminded me not to make it seem too doom and gloom, because he didn't want the powers that be to think we need to move a factory out of Santa Cruz.
Oh yeah.
But you really have to be on it to avoid this. So hopefully I didn't take too much of your time.
No, I think this is exactly why we have the calls, Bob, because this is of course super relevant. From my understanding, so this is really California first, right? And this is also hourly employees only, right?
It's hourly employees only in California. There's certain states like New York, Boston, Massachusetts. They're very employee friendly. California, whereas Texas, the middle of the country, is very employer friendly. So you just have to be careful. And then the other thing I would caution people, especially HR leaders, is many times the business will come to me, and I've had management team members, everybody, where they say, "Hey, I want to make this hourly employee a salaried employee." And there's 4 legal tests on that. And I really caution you, because I was part of a $100 million class action at Target where they made everybody salary so they didn't have to clock in and out, and it really backfires on you. So you have to be very vigilant on exempt classification. There's a vigorous process we go through if a manager wants to make an hourly associate, so they don't have to deal with the timekeeping, a salaried associate.
Yeah.
Thanks, Bob. That's all really helpful. And I know, you guys did a lot of work here, but we've also done a payroll audit here at Cannondale with Pacific Cycle and GT2, just to make sure that we're up on all of these things too. So we're all learning from this. So thank you.
Yeah, and the thing with those audits, it's very important, because you have to also show that you're holding people accountable. When I was at Red Bull, we had a class action lawsuit. We paid dearly because in a 4-year period, we had not fired one employee for violations. We had not written up one employee for violations. So you can have a really good handbook and a policy, but if you don't have documentation where you've written people up or where you've terminated people for manipulating their timekeeping, which happens all the time. So we also had that to our benefit, that we had a history of holding people accountable to violating the law. So cool. Yeah.
It seems like you really have to be on your toes in this kind of matters in America, but especially in California, right? So this the amounts of money that you're talking about are huge. I mean, for European it's hard to understand where it's coming from.
And your payroll manager is really critical. I'd like to recognize Elizabeth Reyes, our global payroll manager. She and I had worked previously on 4 wage and hour lawsuits at our prior company. And she was really critical in identifying patterns, trends, and holding people accountable and calling managers and saying, hey, you're breaking the law. You need to clean this up. So that's a critical position in our HR teams.
No, that sounds like it. Definitely. Thanks for sharing. And I will make sure that I also will share the recording with Chelsea, Michelle. And that's also maybe something we can then forward to others who are interested, because this is definitely important stuff.